This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. I appreciate both of you agreeing to participate in this oral argument by Zoom. It's not necessarily the way we'd like to be doing things, but it is the safest way and the best way for us to continue to conduct business. So we certainly appreciate it. In just a moment, we'll begin the oral arguments, but I want to run over a few of the ground rules here just to make sure everybody's on the same page. We will follow the same rules and procedures that we would be following as if we are in the courtroom. What that essentially means is each side gets 15 minutes to make its oral argument. If you're the appellant and you've previously reserved rebuttal time with Mr. Hivner, you'll receive that rebuttal time as well. Mr. Austin, it's my understanding you are not an attorney. Is that correct, sir?
That's correct.
Okay. What we're going to do today is we're going to hear oral argument. We'll hear your oral argument, then we'll hear opposing counsel's oral argument, but we're not going to render a decision today. What we'll do is take this matter under advisement and we'll write an opinion, and that will be sent to both you and opposing counsel at the same time. So it's not quite like the trial court where a decision's being made today, but hopefully you'll receive an opinion in the next 30 to 60 days.
Thank you.
Is there anything that you have a question about the procedure before we start?
No.
Okay. All right. Before we start, let me introduce today's panel, or this afternoon's panel, rather. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hivner, anything before we start?
I know, Your Honor.
All right, you may call the case.
Aron J. Austin versus Southern Roofing and Renovations, LLC et al.
Mr. Austin, before you start, if you would, tell us your name and then just go ahead and tell us anything you want to about this case.
Aron Austin, pro se for the appellant.
All right, sir, you may proceed.
There's numerous errors in the lower state courts. The first one I would like to address is the jurisdiction. Notice of appeal was published with the Court of Appeals as well as the lower court, and it was properly filed. It was properly published, and the lower court erred in continuing to hold hearings and also dismissing State Farm's motion after notice of appeal had been given. The second issue I would like to address is the res judicata. Boggs versus the City of Cleveland. Unripened cases and claims are not barred by res judicata. Sixth Circuit 2006 ruled in Boggs that if a case or a claim is unripe before the court, res judicata does not attach. Lower court erred in dismissing claims of the 5th and 14th Amendment that wasn't even right before the court to be heard. And that's citing Boggs. The other issue I would like to touch on is the due process, the 5th and the 14th Amendment. The lower court erred in claiming that I was not entitled to the immunities held by the 14th or the 5th Amendment, although I am a born United States citizen. The due process, procedural due process, as well as the equal rights or protections were denied. I had already filed an answer, a motion to continue, and a brief to support that motion to continue. Mr. Tansey was faxed these documents. I followed that phone call up. I also spoke directly with Mr. Tansey, and he had these documents in his possession before he appeared before the court. He appeared before the court with these documents and with this knowledge, and yet he chose to move for a default against me, violating my 5th and 14th Amendment right. Touching back on the jurisdiction of the lower court, I had emailed Judge Hurd's law clerk, Mr. Tansey, on the same email publishing the notice of appeal. I paid the appeal fees, also filed the notice of appeal with the Court of Appeals, and following the steps that you're supposed to take. All the parties knew that the notice of appeal had been published. I was notified on the 7th after the note of the month after the notice of appeal had been published that State Farm in the lower court held a meeting on the motion to dismiss. And Judge Hurd actually entered an order dismissing State Farm's claims after notice of appeal had been given. Once notice of appeal is given, jurisdiction is automatically conferred to the higher court, which is the Court of Appeals. Lower state court no longer holds subject matter jurisdiction. So the lower court erred there. The final one I would like to touch on is the opposing counsel moved for dismissal against Tansey, the 5th and 14th Amendment claims I had, citing the federal statute and the two prongs to a Title 42, Section 1983A. The two prongs is, the first primary prong is you have to be a state actor. In the latter, you have to be abusing your power, which is under color of law. The Title 42, Section 1983 did not apply to Nicholas Tansey. I didn't file the claims as a 1983. And the lower court erred in applying those two prongs in accepting the opposing counsel's argument in dismissing the 5th and the 14th Amendment claims I had against him. And Your Honor, if I may, touching back on the res judicata, applying Boggs, the 6th Court Circuit of Appeals in 2010 and 2011 ruled unripened claims, res judicata cannot attach to unripened claims if the claims are not right before the court to hear. Federal court had just remanded the case. They dismissed without prejudice, left all the claims intact, and sent it back to state court. All the claims were still basically live. They were not, the case was remanded back to state court. We were not even set to hear those claims prior to the lower court entering an order dismissing them. Again, res judicata did not attach if the claims are unripened before the court to even hear. And I think I covered them all.
All right, sir. You've probably got about, and I apologize, but we're having some difficulty with the clock. You probably got about 3.5 minutes left. And you don't have to use all that time, but certainly if you have anything additional you want to say, you can.
That's it, Your Honor.
Okay. All right then. Thank you, sir. We will now hear from the appellee. And of course, you've got whatever rebuttal time that you reserved.
Thank you.
You may proceed.
Thank you. Thank you, Your Honor. May it please the court, Lauren Stimick on behalf of the appellees here, Nicholas Tansey and the Tansey Law Firm. Those are the only two appellees in this appeal. State Farm is not a party to this appeal following the appellant's voluntary dismissal of that and other defendants or appellees from the appeal previously. This matter arises out of work that was performed by Southern Roofing and Renovations, LLC. There was a dispute regarding payment for that work, and so that company hired an attorney, Mr. Tansey, to represent it. He filed suit in Shelby County General Sessions Court on its behalf on January the 4th of 2019, and a judgment was entered on March 27th of that year. On April 11th of 2019, Mr. Austin, the appellant here, appealed that General Sessions judgment to the Circuit Court, as was his right. In doing so, he took advantage of his opportunity to have an entirely new trial in Circuit Court as if the General Sessions trial and judgment had not occurred. He could be heard de novo in the Circuit Court pursuant to Tennessee Code annotated section 27.5.108C, And to the extent he now attempts to raise issues regarding that General Sessions judgment in this appeal before this court, those issues are moot by virtue of that appeal. The instant lawsuit was filed against Mr. Tansey, his law firm, and other defendants on March the 18th of 2020 in Shelby County Circuit Court. Mr. Austin then attempted to serve the defendants via USPS.
Yeah, is that what you just described? Is that the res judicata issue?
There is no res judicata issue in this case as to these appellees. That was not part of the judge's ruling on the motion to dismiss filed by Mr. Tansey.
Because I didn't see anything in the order about res judicata.
It was not in the order as to these appellees. Your Honor is correct.
Okay. All right. Thank you.
It is an issue as to other defendants who are not part of this appeal. And so that legal issue is not part of this appeal.
All right. Thank you.
Thank you, Your Honor. Following his attempts to serve the defendants in the trial court, Mr. Austin filed a return of service on March 31st of 2020 containing virtually no service information, and a second one on May the 6th of 2020 on which he forged Mr. Tansey's signature. In a motion to dismiss filed pursuant to Rule 12 of the Tennessee Rules of Civil Procedure, Mr. Tansey and his law firm, through their counsel, moved for dismissal of all claims based on failure to properly serve them pursuant to Rule 4.04 of the Tennessee Rules of Civil Procedure. Although this service issue is not challenged by Mr. Austin in his notice of appeal or his brief, we raised it in our brief out of an abundance of caution, and I raise it now because it does apply to all claims against these appellees, and it was a basis of dismissal in the trial court's order of all claims.
Where's that set out in the trial court's order? How it dealt with the service of process issue?
That is
that number 11 where it says fails to comply with the requirements for service of process? Item 11.
Yes, Your Honor, that is exactly where it is.
And that was a basis for the dismissal?
It was an alternative basis for the dismissal. Yes, Your Honor, that was a basis that we raised as to all claims. And then each individual claim had an additional basis for dismissal based on the specific nature of that claim. So essentially, each claim was dismissed on two alternative bases.
Thank you.
The requirement for service of process by mail under the Tennessee rules, there are two that are significant here. One is that a registered or certified return receipt be filed. The other is that an affidavit of the person completing service be filed. Neither were filed in this case. After this defense was raised in these appellees' motion to dismiss, no efforts to cure the deficiencies were made, and the statute of limitations has long expired at this point. Mr. Austin has not cited any law to the contrary on this service issue, and so we ask that this court affirm the trial court's ruling that all claims were subject to dismissal on this basis. Of these specific claims with additional specific defenses raised in the trial court, the appellant here has raised two on appeal, and I'll address those two individually very briefly for the court. The first, which has been referenced in the appellant's oral argument, is his constitutional rights claims. Of course, there is no dispute that he has those rights. The defense raised here in, again, the Rule 12 motion to dismiss is that there is no claim upon which relief can be granted under Tennessee law, in this case against these appellees as pled. The appellant takes the position that his constitutional rights claims were not pled as 1983 claims. However, that's the only basis under Tennessee law to do so. Here, even pleading under that basis, this claim cannot proceed because Mr. Tansey is a private individual. His law firm is a private business entity. They're not state actors, and they were not acting under color of state law. In our brief, we cited to a Sixth Circuit case from 1997, Maros versus Kilbane, for the court, which addresses this particular situation even more specifically, holding that an attorney cannot be held liable for a 1983 violation based solely on actions taken on behalf of a client, which is exactly what we have here. Again, the appellant has not cited any law to the contrary on this issue, and so we ask that the trial court's dismissal of this claim for failure to state a claim upon which relief can be granted be affirmed. The second specific claim that is raised in the appellant's brief on appeal here is a claim for violation of Tennessee Code Annotated Section 39-14-114. That is a statute that pertains to forgery. It's a criminal statute. In the motion to dismiss, these appellees filed with the trial court. They took the position that there is no private right of action in Tennessee for a violation of that statute. Tennessee Code Annotated Section 13119A provides that where a criminal statute does not expressly contain language creating or conferring a private right of action for its violation, there is no such right. There is no express language to that effect in this statute, and therefore there is no private right of action for violating it. We cited to a federal district court case in our brief on this issue, Bowman versus Skyview Apartments, where the district court came to the same conclusion as the trial court here, which is that there is no private right of action for violation of this forgery statute. Again, Mr. Austin has not cited to any law to the contrary here, and so we ask that this court affirm the trial court's dismissal of this claim. There are multiple additional claims raised in the trial court, in the appellant's amended complaint, in the motion to dismiss and memo in support these appellees filed, and in the trial court's order dismissing all claims as to these appellees. However, as we asserted in our brief, those additional bases for dismissal were not raised in the notice of appeal or the appellant's brief, and therefore they are waived. With regard to jurisdiction, the trial court's hearing on the motion to dismiss that gives rise to this appeal took place on July the 30th of 2020. The appellant filed a notice of appeal the same day, presumably because the trial court did issue an oral ruling at the conclusion of that hearing. An order was subsequently entered on August the 6th, as is customary, memorializing the court's oral ruling. The appellant again filed a notice of appeal on August the 31st, in which he raised the same issues on appeal as his previously filed notice. It appears that he now takes the position that the trial court did not have jurisdiction to enter its order on August the 6th because that first notice of appeal had been filed the same day. However, that first notice of appeal did not transfer jurisdiction from the trial court to this appellate court at that time because the court had not yet entered an order. The court speaks through its orders, and until it had entered a judgment, there was nothing from which the appellant could appeal. So his initial notice of appeal was treated as premature pursuant to Rule 4D of the Tennessee Rules of Appellate Procedure and deemed filed after the entry of judgment. Again, there is no law cited to the contrary by the appellant here, and it's clear that the trial court did in fact have jurisdiction to enter the order that it entered, dismissing all claims as to these appellees. And we ask that this court affirm that order in all respects. Thank you.
All right. We'll now hear rebuttal from the appellant, Mr. Austin. You have 5 minutes.
Thank you, Your Honor. I would like to touch on the appeal that was raised. The court had entered an oral order on the day that I filed the appeal. The written order was entered later. That's why there was 2 of them filed. Service on Mr. Tansey was done by certified mail, as well as the other defendants in the action. It wasn't just blindly mailed through the United States Post Office. It was actually done through certified mail with return service. Touching back on the federal claims, when the action was filed in state court, it was also filed with the Tennessee state negligence statute attached with it. It wasn't just the 5th and 14th violation. The claim was also for negligence. They touched on the 5th and the 14th Amendment Nowhere in the proceedings did they touch on the claim of my negligence that I had filed against attorney Nicholas Tansey. And that was addressed in the notice of appeal. As touching on the right of action, Mr. Tansey, he is in private practice. He's not a state actor, and he's the two prongs to support a 1983. Again, he has to be a state actor and has to be abusing his power. I never filed it under a 1983. I filed it as a straight violation of negligence with the 5th and the 14th Amendment right violation. All parties were properly served in both actions, the state action as well as the federal action with return service. I would like to touch back on the jurisdiction. Again, once notice of appeal is published in circuit court, the jurisdiction subject matter is automatically transferred to the higher court, which is the Court of Appeals. The Sixth Circuit has ruled in Boggs versus the City of Cleveland that once notice of appeal is published, the lower court automatically loses that jurisdiction is automatically conferred over to the higher court. Circuit Court continued to hold meetings and enter orders after notice of appeal was properly given. For these reasons, I'm asking for the reversal and remand back to the state with direction. Thank you.
Thank you, sir. We appreciate each of your arguments. We will take this matter under advisement and attempt to render an opinion as soon as possible. We again appreciate you participating via Zoom. Ms. Tivner, anything we need to take up before we recess to the call of the next case?
No, Your Honor.
All right. Thank you, sir. You may recess court.
This honorable court is now in recess until 2 p.m.
Thank you, counsel.
Thank you.